and welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss a very, very interesting topic for people who have a lot of commercial disputes, be it infrastructure companies, companies doing business with the government of India, companies in the sense giving service to the government via public procurement contracts. And what we're going to discuss is mediation versus arbitration. How can commercial disputes be solved effectively? Basically, this is an explainer of how things pan out in both processes which come under the alternative dispute resolution framework. It is necessary to discuss this because these ADRs pan out differently in India than what they do in other jurisdictions, because it is a country-specific issue and legal systems have evolved differently. And so how they pan out in India will not be similar to how they pan out in Singapore, Europe, Australia, or other countries. That's why it is good to know for investors who putting money in India, promoters, GCs, so on and so forth. Let me introduce you to my panel. We have with us Senior Advocate Percival Bindumoria. He's a counsel at the Delhi High Court, and the Supreme Court of India. He does a lot of international arbitrations as well as domestic arbitrations. He will bring his perspective on the issue. We have Tahira Karanjawala. She is with Karanjawala and Company. Tahira represents one of India's leading law firms at the Supreme Court of India. Good to see you. I have with me on the show Amit Singh Chauhan. He is senior partner with law firm TKC Partners, and he's also the vice president of the Harvard Club of India, being an alumnus of the Harvard University. Good to see you, Amit. At the outset, let me request Senior Advocate Percival Bindumoria to give an introductory comment before we move on. Over to you, Percival.
There was already a chapter in the Arbitration Act on conciliation. Now, what has happened is that we have this new law pursuant to the Singapore Convention, which incidentally has not yet been ratified. But India is a signatory to the convention. And I think this act probably gives a little more structure and a legal framework to the entire exercise of mediation. Recently, there's been a lot of push from the judiciary to mediate. And I, for one, am a great believer in, even as a lawyer, if somebody comes and says that, can you help us mediate? Or if somebody has a very bad case, I think it's best to say, look, there's no point in fighting this. These are your negatives. In your case, some clients don't like it, of course, India is a very litigious society. Now, the point is that there are two terms here. One is mediation and conciliation, and they are both used interchangeably. Although there was a decision of the Supreme Court that tends to distinguish a little bit in terms of, in conciliation, you can probably try and persuade the parties. In mediation, you can only make suggestions. But now, after this legislation, it's very clear that the terms can be used interchangeably. In fact, now the Arbitration Act refers to this new law. So in a way, it's a very good integration. Now, the point is, in practice, mediation really works well where there are two conditions. One is the parties do not want to litigate. Sometimes there may be extraneous factors, which drive the parties to fight. Ego is one issue. The thing that, okay, I'll show you. That kind of thing. You often find that. So the parties have to be willing. Number two, the lawyers also have to be willing to allow mediation to take place. Let it find, like water find its own level. It works very well, for example, in family courts. And I think family dispute is probably one genus of disputes which is very amenable to mediation, right? But again, there was the Commercial Act, and 12A of the Commercial Courts Act had made mediation mandatory. All right, now there the point is mediation will work only if the parties want to commercially, sound commercial sense dictates that where you can resolve a dispute. The Americans are very good at it. Just throw money at a problem and then move on with your life, right? Move on with business. That's what you're here for, right? So if the parties are pragmatic, both parties are pragmatic, then mediation will work. I don't know whether mandating it is necessarily helpful. On the contrary, sometimes it prolongs the agony. And I often find that some parties, if they are in a sticky position, they say no, please refer it to mediation, because if the judge is sometimes against you, then the tendency is no, please allow us to mediate. We'll find a solution. Then few months later they come back to the court. So I think in a way the courts will have to be a little mindful of this tendency. What is new in this law is the law clearly says that when there is a live matter in court, the court can pass any interim order. So essentially, I think this will really be kind of a status quo, standstill kind of an order. It doesn't say what kind, but I think that's the intent, that, okay, you guys are here at this particular point. Now you're going to mediation, so status quo till the mediation concludes either way. So I think that just about sums it up.
Thank you for that opening comment, Mr. Pilimoria. We'll go to Tahira Karanjawala from Karanjawala and Company. Tahira, you represent a law firm that does a lot of litigations. Of late, we've been seeing that even the courts appoint mediators to solve a dispute in case they want things to move on quickly. But when you make this applicable to commercial disputes, how does this pan out? If you can reflect on that aspect, over to you.
Thank you, Tarun. So this the process of mediation, as Percy sir was rightly pointing out, is largely dependent on the voluntary nature, and the voluntariness of both parties to actually come to a solution. Mediation, both as far as non-commercial disputes are concerned and commercial disputes, as far as both types of disputes are concerned, I think mediation can be a very effective solution if the intent is there. It's effective because it actually shortens the entire process of adjudication. Mediation doesn't actually involve a final decision on disputes. It only contemplates a mediator sort of guiding the two parties to find a solution that's mutually acceptable. Another interesting aspect of mediation is that unlike an arbitration or a court dispute, where the scope of the dispute is more narrowly defined, as far as mediation is concerned, the mediation process can take into account various other factors which may not be strictly within the scope of the reference to the mediation. This helps to actually find creative solutions both in a commercial space as well as a non-commercial space. It also, this new act has, in a sense, streamlined the process. Because earlier what would happen, is a court would refer a dispute to mediation, then you would have, this for months and months, the dispute would be lingering with the mediator, parties would come, give a proposal, it may not necessarily find favor with the other party, and it would go on endlessly. Now there's a sort of a time frame prescribed of 120 days with an additional 60 days if the parties agree. So I think that will help to streamline the process, because it's important that even alternative dispute resolution mechanisms are sort of sensitive to time, because I think that that's the point of having these solutions. And I think another good aspect of this new law is that now a mediated settlement agreement is enforceable like a decree of the court. And because it is especially in a commercial dispute, because both sets of parties have, in a sense, come to the conclusion which is now recorded in the agreement, there are less chances of a challenge. And even a challenge is contemplated on very narrow very narrow parameters such as impersonation or corruption or a fraud, which goes to the consent of the party concerned. So I think all these factors make mediation a very attractive solution if the intent is there to cut costs and actually find a solution. If, of course, as Percy said, the intent is to sort of if the premise is to fight with the other party, then of course mediation, like any other process, will not work.
Point well taken, Tahira. We'll talk to you some more on that on the next question. Now we'll go to Amit Singh Chauhan, senior partner with TKC and Partners, for his opening intervention. Over to you, Amit.
It's a welcome act, broadens the scope of say whatever is covered in the arbitration. You're restricted by the scope of reference. Here, while you're referring a dispute to mediation, you're not restricted to only the scope of reference. Apart from that, I agree with Percy sir and Tahira. As long as parties are willing to settle a dispute, this will be effective, and as long as the courts are adhering to the strict timelines. In India, the laws sometimes are very good, but the implementation on the ground, there is extension of time which actually frustrates the entire purpose of the act. We have seen this with Sarfazi, DRT Act, even the IBC of late. So, plus this act also includes the community mediation, which is like the panchayat system, which has already existed. Plus, it also includes compoundable offenses. Most of the offenses or litigations or commercial disputes, and as long as people are willing to recognize the time value of money in India, commercial disputes will be settled. Money in hand right now is much better than money you will have 6-7 years after litigating in India, which is the normal commercial, even in a commercial dispute. While there are timelines in the Commercial Courts Act, not implemented strictly. So as long as the commercial disputes, time value of money. Compoundable offenses, welcome step, because our courts are overburdened with miscellaneous, 420s and a lot of compoundable offenses therein. The only thing I see is consumer disputes not specifically being included, or maybe industrial disputes to some extent, and the SEBI Act specifically being excluded. In other countries, SEC for US, whether you plead guilty or whether you settle the dispute, you make the payment and you're out of it. But in India, these disputes have been separately kept outside, probably believing that it's an in rem step rather than an in personam effect at the end of the day.
Point very well taken. I'll now go across to Senior Advocate Percival Villimoria. I want to know from you, in India, there are different kinds of arbitrators or litigators. They are habitual litigators. Many times people bid and then enter an arbitration, invoke the arbitration clause. So, there are kinds and kinds of disputes. And given this peculiar environment in India where these things happen, how does mediation fall in this space? Because when I am not intending to agree on something, then there is no common ground. I want to disagree on something, or maybe force you to accept my point. In that case, does mediation lose out?
Yeah, so no case is ever perfect. So look, when you go to court, you should evaluate your own case. And you will know that, okay, this is a slight weakness in my case. And and the other side will know your weaknesses and know their own weaknesses. And I think it is only when both parties, resolve that, look, this is very complicated. It's going to take time, money, and it'll drag us down. See, a lot of litigation does drag down. Commercially, it is always good to settle a dispute. But this is also a question of attitude, because, as I said, the Americans really have this attitude. Okay, this guy is saying that he needs money to give me approval. Agreement says that I need his approval. Here's the money. Let me just get on with life. Because in the interim period, rather than fighting him, I'll make much more money. And that is a businessman's approach. So to that extent, I think, commercial disputes really lend themselves. It makes a great deal of sense. The problem is that if parties really want to mediate, they believe that mediation can work, I don't know whether you really need a law that mandates it. Because when you say that mediation is mandatory, people will misuse it. So as I said, if someone believes that, okay, you are, before a bench which is not taken kindly to your arguments, you will try to defer the matter and say, please. Very often I hear somebody saying, but this is the third time we are going to mediation. That we've tried this before, right? But then always the bench will try to urge settlement, if it is at all possible. Another thing, Tarun, there's one very good feature about this law, especially when you come to arbitration. So it clearly says that the time taken for mediation will be excluded for the purpose of limitation. Now, this was a very big issue because I have had situations where, the parties exchange legal notices and then one party kind of says, yes, don't worry, we are going to come and talk to you. Oh, we couldn't talk, because of some reason, defer it. And then, sure enough, later on, when the arbitration starts, they say, okay, now you're out of limitation. Okay, and there are some very interesting judgments on this. So I think it's a very welcome development to say that whatever time you take for mediation is excluded.
Point very well taken, Mr. Bilimori. I'll go to Taira Karanjawala from Karanjawala and Company. Taira, whenever one party feels that they are on the side of a victory, or they have a claim which is valid and the courts will uphold that right, that party may or may not be interested in going for mediation because it may feel that it has a stronger chance of victory before the courts of law. In such an environment, how do you look at, say, construction projects where if you are, say, implementing a 10,000 crore projects, there are many disputes which occur between vendors and the principal, and there is a time limit for the project completion, cost overruns happen and the project is late. The applicability of mediation in such cases, A, and secondly, is it being done enough these days, or there is a lot more scope, and have the companies adopted to it?
Thank you, Tarun. So Tarun, actually, you brought up a very valid, question. What happens in these large at the moment, many of these agreements are now under arbitration clauses. So a large number of disputes are now before arbitral tribunals. I have at least found in my practice that arbitral tribunals are quite willing to refer the parties to a mediation, or to refer them to at least settle the disputes inter se, if the parties are willing to do that. So, in fact, as we were discussing earlier before this call, the new office memorandum, which has suggested that the government in public procurement contracts should avoid arbitration clauses over a certain value, and should, while they should try and mediate disputes, they should not include arbitration clauses. I personally don't agree with the philosophy behind that new advisory, because I think that while mediation is a very commendable process, as you rightly said, when there are thousands of crores involved and a party is sort of very sure that they have a legal right which will be upheld eventually, then it is unfair to expect them to accept a very largely reduced settlement amount, which is what happens sometimes when you have unequal negotiating power between parties. So that's, I think, the one disadvantage of mediation, which is that often parties may not, because you're avoiding the actual adjudication of the dispute, you have a situation where parties with more negotiating power, such as the government, may use that to, browbeat settlements that are otherwise not, which in the normal course, had that dispute been adjudicated, the award may have been in favor of the contractor. So I think that a combination of both arbitration and mediation is probably the better way to go about it, because if you have a situation where you only have mediation and And no, without that solution, you have to go back into the regular court system. Then you're looking at extremely delayed, protracted litigations for very large contracts, and eventually you will have a situation where private contractors may hesitate to get into such contracts because they don't have arbitration clauses, especially foreign parties. So I think a good combination of the two is useful, so that a party knows if you can't get a solution through mediation, there is a time effective arbitration which is at their disposal, which then can go on and proceed and give them a proper solution.
Thank you for explaining this, Tahira. This was interesting to note. I will go across to Amit Singh Chauhan from TKC and Partners for his intervention, especially when you look at infrastructure and construction. Because so much of this activity is currently on in India, and for the foreseeable future, the largest amount of investments are going into this sector. B, it also results in the most amount of disputes. Even while the project is being implemented, there are running disputes that happen all the time. And I think Mr. Bilimoria will be able to throw some insight when he speaks on that later. But over to you now, Mr. Chauhan, for your intervention.
See, most of these PSU contracts have an interim dispute resolution clause while the contract is ongoing, so that the contract is not affected or the timelines are not affected. And as Tahira was saying, there are huge contracts, mediation, arbitration, combination is perfect. In almost all PSU contracts, arbitration clause is preceded by a conciliation clause. But what happens, in fact, is because all these PSUs have a dispute resolution board, so those conciliation, in effect, turn into mediation. Into arbitration, because all the pleadings have to be submitted, notes have to be submitted, arguments have to be submitted. So in effect, it delays the claim. And since it's a commercial transaction, at the end of the day, one of the parties might feel frustrated and otherwise, right? But under this act, mediation, a mediator cannot act as an arbitrator. That is a good aspect of this act. It will shorten the timelines, in effect, especially where arbitration clauses are there and involves a PSU which is there. And as far as Mr. Bilmoria was saying, US is a very settlement oriented and mediation oriented. There's only one specific reason for that: the cost of litigation, in effect, and the damages which they can impose. So if it's a trial by jury damages, all of us know damages can be insane. But in India, the costs are minuscule. The court will give you 25,000, 20,000, even if you have a long drawn litigation. Start imposing the cost, and you will see the next day, people will start moving towards mediation. Once they know the consequences of long drawn litigation or the consequences of not adopting a procedure which is there at your disposal, and you are carrying on litigation to placate your egos, even if it's a commercial dispute. Once that is there, the disputes will head towards mediation and settlement.
Thank you for that intervention, Amit. I'll go to Mr. Percival Bilimoria. Mr. Bilimoria, often enough I've heard you speak that when you do international arbitrations, they are conducted in a very time-bound manner. Even the cross-examination, all these procedures happen back-to-back. So, you don't, there is no time lag for the client or the party. Do you think swift, quick arbitration is the answer in case mediation fails? A time-bound, quick arbitration where, you deliver for the client. In case if, for example, it's a road project where, say, 500 kilometers of road is to be built, it leads to multiple disputes during the course of the construction work. It could be anything from cost of raw materials going up to various other issues. Could you reflect on that? I mean, what we could do in India, given the fact that $150 billion of investments are going to go into infrastructure in this country in the coming few years, looks to me that we are going to have lots and lots of disputes. And It's the legal system that has to cater to it, to solve it. It's a service industry in that sense.
Correct.
Over to you for your intervention.
Yeah, so Tarun, you're very right. I mean, we need time-bound dispute resolution. Remember, one more aspect is that arbitration is also referred to as alternative dispute resolution, TDR, right? So that's just an aside. But yes, time-bound, but what happens internationally is also not time-bound. There's no mandatory period within which you have to finish the arbitration. It's just that the process is such. The process is very well oiled. And as I've been saying, that there is generally, if you have international arbitration, it's over a week, 5 days, Monday to Friday. Okay, what is known as chess clock arbitration. Both parties have the same amount of time. Now, that would be very, very desirable. There are also other process issues, and I've identified the lack of transcripts as being a huge issue. But how are you going to go there? And I'm telling you, no matter what happens, forget the office memorandum. No matter what happens, until the process changes, arbitration in India is a non-starter. Let's be very clear about it. If you want to compete, right, you don't compete by mandating things. You compete by creating the environment. It can be very easily done. So what prevents it? It's something which is very easily done. It's just a question of learning. So, for example, now we have a new arbitration bar, which is a good start, right? But the same people who are counsels in arbitration will also do court work, and I myself will have a very tough decision to make as to when it is mandated that okay, you can only be part of the arbitration bar or you can do litigation. It'll be a very difficult choice, right? So I'm myself guilty, but that is the environment that we have today. So most of the arbitrations are after 4 o'clock on weekdays. It just doesn't work. Also, just to round up, I think Amit and Tyra made a couple of very good points. So coming to construction, contracts, there is often because these contracts are sometimes long drawn out over a period of a few years. So there is an interim dispute resolution mechanism where a dispute can be referred to an internal team. So they say, okay, if you have any dispute, then you can escalate it up the ladder. So maybe the project manager and then sometimes go to the CEO. But now I've had situations where peculiarly that happens, and then if it doesn't get resolved, it is parked. Now, while you are still executing the project, nobody wants to get into arbitration, right? So you will not trigger arbitration at that point. And typically the government contractors, the government and all its constituents, you'll find typically the last 10% is always withdrawn. You see it so often. 90% payment made, the last 10% is held back on some pretext or the other. And then you go into litigation or arbitration. So, a very interesting position had emerged as to, when does the cause of action happen? So let's say there is a dispute that happened more than 3 years ago, couldn't get resolved, and you parked it for the last 10%. Now, there are certain judgments that say that in running account payments, the cause of action happens only when the last installment is withheld, because that is when you will do your final settlement. Right? So you don't, otherwise what will happen is that you don't trigger arbitration and then you are barred by limitation. So these are very interesting nuances in construction law. And but I think, our courts have really set out the correct jurisprudence on all these things. The problem is not with the law. It's not with the legal system. The problem is in the process.
Thank you, Percival. Point very well taken. We are almost out of time on this one, but we reassemble as a panel soon again to focus on construction disputes more, given that it is a large piece of the pie. there'll be a lot more construction disputes in India than disputes in any other sector. This is what we see. But I would like to thank each one of you for making time, joining us on such an important topic, and looking forward to invite you for the part 2 and on this very topic with more focus on infra and construction arbitration. Thank you for joining in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.